rises. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between, yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between, yeah.
Hey guys, how are y'all doing? Welcome to another video. All right, we're here to get into some court updates pertaining to Megan Thee Stallion versus Milagro Elizabeth Cooper. Now, before we actually get started, y'all know how I got to put up my disclaimer here. Copyright under Section 107, just simply saying, hey, this is fair use. I am not a paralegal. I am not an attorney, and I am not a judge. I am simply saying that, hey, I know how to read. And without further ado, we are here to get into the plaintiff, which is Megan Thee Stallion's proposed jury instructions. So let's get right into it, okay? Now, there is 39 pages. It's pretty lengthy, so make sure you grab your snacks, grab your drink, grab you some wine, grab you some beer, grab you some liquor, whichever, and have a seat, and let's read, okay? So this is plaintiff's proposed jury instructions. Pursuant to the court's case management and scheduling order, which is docket 62, plaintiff Miss Pete, respectfully submits her proposed jury instructions. Ms. Pete respectfully reserves her right to amend her jury proposed instructions prior to the time it is given to the jury, depending on the evidence received at trial, the court's rulings, or any other factors that preclude a definitive submission at this time. All right, so let's scroll down. Instruction number 1.1, general preliminary instruction. Members of the jury, now that you've been sworn, I need to explain some basic principles about a civil trial and your duty as jurors. These are preliminary instructions. I'll give you more detailed instructions at the end of the trial. The jury's duty. It's your duty to listen to the evidence, decide what happened, and apply the law to the facts. It's my job to provide you with the law you must apply, and you must follow the law even if you disagree with it. What is evidence? You must decide the case on only the evidence presented in the courtroom. Evidence comes in many forms. It may be testimony about what someone saw, heard, or smelled. It can be an exhibit or a photograph. It can be someone's opinion. Some evidence may provide or may prove a fact indirectly. Let's say a witness saw wet grass outside and people walking into the courthouse carrying wet umbrellas. This may be indirect evidence that it rained, even though the witness didn't personally see it rain. Indirect evidence like this is also called circumstantial evidence, simply a chain of circumstances that likely proves a fact. As far as the law is concerned, it makes no difference whether evidence is direct or indirect. You may choose to believe or disbelieve either kind. Your job is to give each piece of evidence whether weight you think it deserves. What is not evidence? During the trial, you'll hear certain things that are not evidence, and you must not consider them. First, the lawyer's statements and arguments are evidence. In their opening statements and closing arguments, the lawyers will discuss the case. Their remarks may help you follow each side's arguments and presentation of evidence. But the remarks themselves are evidence and shouldn't play a role in your deliberations. Second, the lawyer's questions and objections are evidence. Only the witness's answers are evidence. Don't decide that something is true just because a lawyer's question suggests that it is. For example, a lawyer may ask a witness, "You saw Mr. Jones hit his sister, didn't you?" That question is not evidence of what the witness saw Mr. Jones did, unless the witness agrees with it. There are rules of evidence that control what the court can receive into evidence. When a lawyer asks a witness a question or presents an exhibit, the opposing lawyer may object if he or she thinks the rules of evidence don't permit it. If I overrule the objection, then the witness may answer the question or the court may receive the exhibit. If I sustain the objection, then the witness cannot answer the question and the court cannot receive the exhibit. When I sustain an objection to a question, you must ignore the question and not guess what the answer may have been or might have been. Sometime I may disallow evidence. This is also called striking evidence in order you to disregard or ignore it. That means that you must not consider that evidence when you are deciding the case. I may allow some evidence for only a limited purpose when I instruct you that I have admitted an item of evidence for a limited purpose. You must consider it for only that purpose and no other. Credibility of witnesses. To reach a verdict, you may have to decide which testimony to believe and which testimony not to believe. You may believe everything a witness says, part of it, or none of it. When considering a witness testimony, you may take into account, and y'all see there's bullet points here, the witness opportunity and ability to see, hear, or know the things that the witness is testifying about, the witness memory, the witness manner while testifying, any interest the witness has in the outcome of the case, any bias or prejudice the witness may have, any other evidence that contradicts the witness testimony, the reasonableness of the witness's testimony in light of all the evidence, and any other factors affecting believability. At the end of the trial, I'll give you additional guidelines for determining a witness credibility. Description of the case. This is a civil case. To help you follow the evidence, I'll summarize the parties' positions. The plaintiff, Miss Megan Pete, claims the defendant, Miss Milagro Cooper, defamed her by falsely accusing her of committing the crime of perjury, being an alcoholic, and being mentally incapacitated and either needing or already having a guardian. Second, Miss Pete alleges that Miss Cooper promoted a deep fake pornographic video of Miss Pete, despite reasonably knowing that the visual depiction was artificially created. Third, Miss Pete claims that Miss Cooper intentionally engaged in this conduct and that the conduct caused her severe emotional distress. Fourth, Miss Pete claims that Miss Cooper engaged in cyber stalking by engaging in this behavior through electronic means. Burden of proof. Miss Pete has the burden of providing her case by what the law calls a preponderance of the evidence. That means Miss Pete must prove that, in light of all the evidence that she claims is more likely true than not. So, if you could put the evidence favoring Miss Pete and the evidence favoring Miss Cooper on opposite sides of balancing scales, Miss Pete needs to make the scales tip on her side. If Miss Pete fails to meet this burden, you must find in favor of Miss Cooper. To decide whether any fact has been proved by a preponderance of the evidence, you may, unless I instruct you otherwise, consider the testimony of all witnesses, regardless of who called them, and all exhibits that the court allowed, regardless of who produced them. After considering all the evidence, if you decide a claim or fact is more likely true than not, then the claim or fact has been proved by the preponderance of the evidence. On certain issues called affirmative defenses, Ms. Cooper has the burden of proving the elements of a defense by the preponderance of the evidence. I'll instruct you on the facts Ms. Cooper must prove for any affirmative defense. After considering all the evidence, If you decide that Ms. Cooper has successfully proven that the required facts are more likely true than not, the affirmative defense is proved. Conduct of the jury. While serving on the jury, you may not talk with anyone about anything related to the case. You may tell people that you're a juror and give them information about when you must be in court, but you must not discuss anything about the case itself with anyone. You shouldn't even talk about the case with each other until you begin your deliberations. You want to make sure you've heard everything, all the evidence, the lawyer's closing arguments, and my instructions of the law before you begin deliberating. You should keep an open mind until the end of the trial. Premature discussions may lead to a premature decision. In this age of technology, I want to emphasize that in addition to not talking face to face with anyone about the case, you must not communicate with anyone about the case by any other means. This includes emails, text messages, phone calls, and the internet, including social networking websites and apps such as Facebook, Instagram, Snapchat, YouTube, and Twitter. You may not use any similar technology of social media, even if I have not specifically mentioned it here. You must not provide any information about the case to anyone by any means whatsoever. And that includes posting information about the case or what you are doing in the case on any device or internet site, including blogs, chat rooms, social websites, or any other means. You also shouldn't Google or search online or offline for any information about the case, the parties, or the law. Don't read or listen to the news about this case. Visit any places related to this case or research any fact, issue, or law related to this case. The law forbids the jurors to talk with anyone else about the case and forbids anyone else to talk to the jurors about it. It's very important that you understand why these rules exist and why they are so important. You must base your decision only on the testimony and other evidence presented in the courtroom. It is not fair to the parties if you base your decision in any way on information you acquire outside the courtroom. For example, the law often uses words and phrases in special ways. So it's important that any definitions you hear come only from me and not from any other source. Only you jurors can decide a verdict in this case. The law sees only you as fair, and only you have promised to be fair. No one else is so qualified. Taking notes. If you wish, you may take notes to help you remember what the witness said. If you do take notes, please don't share them with anyone until you go to the jury room to decide the case. Don't let note taking distract you from carefully listening and observing the witness. When you leave the courtroom, you should leave your notes hidden from view in the jury room. Whether or not you take notes, you should rely on your own memory of the testimony. Your notes are the only, or are there only to help your memory. They're not entitled to greater weight than your memory or impression about the testimony. Then it says course of the trial. Let's walk through the trial. First, each side may make an opening statement, but they don't have to. Remember, an opening statement isn't evidence, and it's not supposed to be argumentative. It's just an outline of what that party intends to prove. Next, Ms. Pete will present her witness and ask them questions. After Ms. Pete questions the witness, Ms. Cooper may ask the witness questions. This is called cross-examining. Okay, the witness. And it says, then Ms. Cooper will present her witness and Ms. Pete may cross-examine them. You should base your decision on all the evidence, regardless of which party presented it. After all the evidence is in, the party's lawyers will present their closing arguments to summarize, interpret the evidence for you, and then I'll give you instructions on the law. You'll then go to the jury room and deliberate. Instruction 2. This is 1.2, burden of proof, clear and convincing evidence. Sometimes a party has a burden of proving a claim or defense by clear and convincing evidence. This is a higher standard of proof than proof by a preponderance of the evidence. It means the evidence must persuade you that the claim or defense is highly probable or reasonably certain. The court will tell you when to apply this standard. Then, instruction number 3, which is jury questions. During this trial, you may submit questions to a witness after the lawyers have finished their own questioning. Here is how the procedure works. After each witness has testified and the lawyers have asked all their questions, I'll ask if any of you have questions. If you have a question, write it down and give it to the court staff. You may submit a question for a witness only to clarify an answer or help you understand the evidence. Our experience with juror questions indicates that jurors rarely have more than a few questions for any one witness, and there may be no questions at all for some witnesses. If you submit a question, the court staff will give it to me and I'll share your questions with the lawyers in the case. If the rules of evidence allow your question, one of the lawyers or I will read your question to the witness. I may modify the form or phrasing of a question so that it's allowed under the evidence rules. Sometimes I may not allow the questions to be read to the witness, either because the law does not allow it or because another witness is in a better position to answer the question. If I can't allow the witness to answer the question or a question, you must not draw any conclusions from that fact or speculate on what the answer might have been. Here are several important things to keep in mind about your questions for the witness. And as y'all can see here, there's 3 bullet points. Okay. First, you must submit all questions in writing. Please don't ask any questions aloud. Second, the court can't recall witness to the stand for additional juror questions. If you have a question for a particular witness, you must submit it when I ask. Finally, because you should remain neutral and open-minded throughout the trial, you should phrase your questions in a way that doesn't express an opinion about the case or a witness. You must keep an open mind until you've heard all the evidence, the closing arguments, and my final instructions of the law. Instruction number 4, which is stipulations. Sometimes the parties have agreed that certain facts are true. This agreement is called a stipulation. You must treat these facts as proved for the case. And then instruction number 5, which is use of depositions. A deposition is a witness sworn testimony that is taken before the trial. During a deposition, the witness is under oath and swears to the truth, and the lawyers for each party may ask questions. A court reporter is present and records the questions and answers. The deposition of name of witness taken on date is about to be as been presented to you by a video by reading the transcript. Deposition testimony is entitled to the same consideration as live testimony, and you must judge it in the same way as if the witness was testifying in court. Do not place any significance on the behavior or tone of voice of any person reading the questions or answers. Instruction number 6, use of recorded conversations and transcripts. Now, you're going to hear a recorded conversations. This is proper evidence for you to consider. Please listen to it very carefully. I'm going to allow you to have a transcript of the recording prepared by a name of preparer to help you identify speakers and guide you through the recording. But remember, it is the recording that is evidence, not the transcript. If you believe at any point that the transcript says something different from what you hear on the recording, disregard that portion of the transcript and rely instead on what you hear. Instruction number 7, which is judicial notice. The rules of evidence allow me to accept facts that no one can reasonably dispute. The law calls this judicial notice. I've accepted state the fact that the court has judicially noticed as proved, even though no one introduced evidence to prove it. You must accept it as true for this case. And then we're going to go to instruction number 8, which is use of interrogatories. You've heard answers that name of party gave in response to written questions the other side submitted. The questions are called interrogatories. Before the trial, name of party gave the answers in writing while under oath. You must consider name of party's answers to as though name of party gave the answers on the witness stand. Instructions number 9, which is in-trial instructions on news coverage. Reports about this trial may appear in the media. The reporters may not have heard all the testimony as you have, may be getting information from people who are not under oath and subject to cross-examination, may emphasize an unimportant point, or may simply be wrong. You must not read, listen to, or watch anything about this trial. It would violate your oath as a juror and decide this case on anything other than the evidence presented at trial and on your own common sense. You must decide this case exclusively on the evidence you receive here in court. Instruction number 10 which is introduction and final charge to jury. Court's instructions to the jury. Members of the jury, it's my duty to instruct you on the rules of law that you must use in deciding this case. When I have finished, you will go to the jury room and begin your discussions, sometimes called deliberations. Instruction number 11, duty to follow instructions. No corporate party involved. Your decision must be based only on the evidence presented here. You must not be influenced in any way by either sympathy for or prejudice against anyone. You must follow the law as I explain it, even if you do not agree with the law, and you must follow all of my instructions as a whole. You must not single out or disregard any of the instructions of the law. Instruction number 12. Consideration of direct and circumstantial evidence, argument of counsel, comments by the court. You must consider only the evidence that I have admitted in the case. Evidence includes the testimony of witnesses and the exhibits admitted, but anything the lawyers say is not evidence and isn't binding on you. You shouldn't assume from anything I've said that I have any opinion about any factual issue in the case. Except for my instructions to you on the law, you should disregard anything that I may have said during the trial and arriving at your own decision about the facts. Your own recollection and interpretation of the evidence is what matters. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You shouldn't be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances that tend to prove or disprove a fact. There is no legal difference in the way you may give to either direct or circumstantial evidence. Instruction number 13, credibility of witnesses. When I say you must consider all the evidence, I don't mean that you must accept all the evidence as true or accurate. You should decide whether you believe what each witness has to say or had to say, and how important that testimony was. In making that decision, you may believe or disbelieve any witness in whole or in part. The number of witnesses testifying concerning a particular point doesn't necessarily matter. To decide whether you believe any witnesses or witness, I suggest that you ask yourself a few questions. And then as y'all can see here, okay, there are 7 questions. Question number 1, did the witness impress you as one who was telling the truth? Question 2, did the witness have any particular reason not to tell the truth? Question 3, did the witness have a personal interest in the outcome of the case? Question 4, did the witness seem to have a good memory? Question 5, did the witness have the opportunity and ability to accurately observe the things he or she testified about? Question 6, did the witness appear to understand the questions clearly and answer them directly? And then question 7, which is last, did the witness testimony differ from other testimony and other evidence? Okay, so let's get into instruction number 14. Impeachment of witnesses because of inconsistent statements or felony conviction. You should also ask yourself whether there was evidence that a witness testified falsely about an important fact, and ask whether there was evidence that at some other time a witness said or did something, or didn't say or do something that was different from the testimony the witness gave during this trial. To decide whether you believe a witness, you may consider the fact that the witness has been convicted of a felony or a crime involving dishonesty or a false statement. But keep in mind that a simple mistake doesn't mean a witness wasn't telling the truth as he or she remembers it. People naturally tend to forget some things or remember them inaccurately. So, if a witness misstated something, you must decide whether it was because of an innocent lapse in memory or an intentional deception. The significance of your decision may depend on whether the misstatement is about an important fact or about an unimportant detail. Now, instruction number 15, which is witness or expert witness. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in the field is allowed to state an opinion about the matter. But that doesn't mean you must accept the witness' opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. Instruction number 16, responsibility for proof, plaintiff's claims, cross claims, counterclaims, preponderance of the evidence. In this case, it is responsibility of Ms. Pete to prove every essential part of her claims by a preponderance of the evidence. This is sometimes called the burden of proof or the burden of persuasion. The preponderance of the evidence simply means an amount of evidence that is enough to persuade you that Ms. Pete's claim is more likely true than not true. If the proof fails to establish any essential part of a claim or contention by a preponderance of the evidence, you should find against Ms. Pete. Because more than one claim is involved, you should consider each claim separately in deciding whether any fact has been proved by a preponderance of the evidence. You may consider the testimony of all the other witnesses, regardless of who may have called them, and all of the exhibits received in evidence, regardless of who may have produced them. If the proof fails to establish any essential part of Ms. Pete's claims by a preponderance of evidence, you should find for Ms. Cooper to that claim. Instruction number 17, responsibility for proof, affirmative defense, preponderance of the evidence. In this case, Ms. Cooper asserts the affirmative defense of defendant to identify defenses. Even if Ms. Pete prove her claims by a preponderance of the evidence, Ms. Cooper can prevail in this case if she proves an affirmative defense by a preponderance of evidence. When more than one affirmative defense is involved, you should consider each one separately. I caution you that Ms. Cooper does not have to disprove Ms. Pete's claims. But if Ms. Cooper raises an affirmative defense, the only way she can prevail on that specific defense is if she proves that defense by a preponderance of the evidence. And then instruction number 18, greater weight of the evidence. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in this case. And then instruction number 19, which is clear and convincing evidence. Clear and convincing evidence differs from the greater weight of the evidence, and that is more compelling and persuasive. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion. Oh, excuse me, y'all give me 1 second. Okay, sorry about that. Lacking in confusion and of such weight that it produces a firm belief of conviction without hesitation about the matter in issue. And then instruction number 20, which is defamation. The plaintiff, Ms. Pete, claims that the defendant, Ms. Cooper, defamed her by publishing false statements about her on social media, which caused Ms. Pete's harm. Ms. Pete claimed Ms. Cooper defamed her by making the following statements: that Ms. Pete's committed perjury, a felony, by lying under oath in a criminal trial, that Miss Pete is mentally incapacitated, slow, or legally retarded, or either has or requires a guardian, and that Miss Pete is an alcoholic or comes from a family of addicts. Defendant to identify defenses in her proposed instructions. The issues you must decide for Ms. Pete's claim of defamation against Ms. Cooper are: first, whether Ms. Cooper published a statement about Ms. Pete; second, whether the statement was in some significant respect false, and whether Ms. Cooper either knew the statement was false or had serious doubts as to its truth; third, whether the statement was defamatory, and if so, fourth, whether Ms. Cooper's defamatory statement was a legal cause of loss, injury, or damage to Ms. Pete. The first issue you must decide is whether Ms. Cooper published the statements. A statement is published when it is communicated to someone other than Ms. Pete or Ms. Cooper. In order to be communicated, a statement must be read, seen, or heard by a person other than Ms. Pete or Ms. Cooper, and that person must understand the statement's significance. A separate publication occurs each time Ms. Cooper communicates the statement to someone other than Ms. Pete, except that a single communication read, seen, or heard at the time by two or more people is only a single publication. The next issue for you to decide is whether Ms. Cooper's statement concerning Ms. Pete's was in some significant respect a false statement or fact, and if so, whether at the time the statement was made, Ms. Cooper either knew the statement was false or had serious doubts as to its truth. A statement is in some significant respect false if its substance or just conveys a materially different meaning than the truth would have conveyed. In making this determination, you should disregard any minor inaccuracies that do not affect the substance of the statement. A statement that is literally true is in some significant respect a false statement or a fact. It is conveyed in such a way as to create a false impression. In order to be regarded as defamatory, a statement must be one of fact, not opinion. However, a statement involved or phrased as opinion is considered to be a statement of fact. It is if it is capable of being proved false, or if it implies a knowledge of unstated facts that would support the opinion. You must decide whether clear and convincing evidence shows that at the time the statement was made, Ms. Cooper either knew the statement was false or had serious doubts as to its truth. Ms. Pete's defamation claim is what is known under Florida law as defamation, which is per se. Florida law holds that certain statements are so harmful in nature that they are presumed defamatory as a matter of law. In a claim for defamation per se, the harmful nature of the statement is apparent from the words in the statement itself. Therefore, the plaintiff in a defamation per se action does not need to allege damages because the harm is readily apparent. The court has determined that the statements Ms. Pete complains of are defamatory per se. Therefore, you may assume as part of your deliberation that these statements are defamatory. Next, you must decide whether the statement was a legal cause of loss, injury, or damages to Ms. Pete. A statement is a legal cause of loss, injury, or damage if it directly in a natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage, so that it can reasonably be said that but for the statement, the loss, injury, or damage would not have occurred. In order to be regarded as a legal cause of loss, injury, or damage, a statement need not be the only cause. A statement may be a legal cause of loss, injury, or damage, even though it operates in combination with the act of another or some other cause if the statement contributes substantially to producing such loss, injury, or damage. Ms. Pete must prove the second element, falsity, by clear and convincing evidence. Clear and convincing evidence is a higher standard of proof than proof by a greater weight of the evidence or preponderance of the evidence. It means the evidence must persuade you that the claim or defense is highly probably or reasonably certain. If Ms. Pete has not proven falsity by clear convincing evidence, then your verdict should be for Ms. Cooper. If the greater weight of the evidence or preponderance of the evidence does not support the other elements of Ms. Pete's defamation claim, then your verdict should be for Ms. Cooper. However, if Ms. Pete has proven her claim, then you will consider the defenses raised by Mrs. Cooper. Instruction number 21, which is intentional infliction of emotional distress. Okay, we're almost there, guys. We're on page 30 of 39. We're almost there. Ms. P claims that Ms. Cooper acted extremely and outrageously by coordinating with Mr. Daystar Peterson and others to distribute false statements about Ms. Pete to promote and distribute an altered sexual depiction of Ms. Pete, which caused her severe emotional distress. Defendant denies plaintiff's claim. Defendant to identify defenses in her proposed instructions. The issues for you to decide on Ms. Pete's claim of intentional infliction of emotional distress are: first, whether Ms. Cooper engaged in extreme or outrageous conduct. Second, whether Ms. Cooper acted with the intent to cause severe emotional distress or with reckless disregard of the high probability of causing severe emotional distress. Third, whether that extreme or outrageous conduct was a legal cause of severe emotional distress to Ms. Pete. Extreme and outrageous conduct is behavior which, under the circumstances, go beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. Emotional distress is severe when it is of such intensity or duration that no ordinary person should be expected to endure it. Extreme and outrageous conduct is a legal cause of severe emotional distress if it directly in natural and continuous sequence produce or contribute substantially to producing such severe emotional stress, so that it can reasonably be said that but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. In order to be regarded as a legal cause of severe emotional distress, extreme and outrageous conduct need not be the only cause. Extreme and outrageous conduct may be a legal cause of severe emotional distress, even though it operates in combination with the act of another or some other cause, if the extreme and outrageous conduct contributes substantially to producing such severe emotional distress. If the greater weight of the evidence or preponderance of the evidence does not support Ms. Pete's claim, your verdict should be for Ms. Cooper. However, if the greater weight of the evidence support Ms. Pete's claim, then your verdict should be for Ms. Pete and against Ms. Cooper. Then you shall consider the defense raised by Ms. Cooper. If the greater weight of the evidence supports the defense, your verdict should be for Ms. Cooper. However, if the greater weight of the evidence does not support the defense, your verdict should be for Ms. Pete and against Ms. Cooper. Instruction number 22, promotion of an altered sexual depiction. Ms. Pete claims that defendant willfully and maliciously promoted a deepfake pornographic video of Ms. Pete on social media without Ms. Pete's consent. Ms. Pete alleges that Ms. Cooper knew or reasonably should have known that the visual depiction of plaintiff was, in fact, an altered sexual depiction, more commonly known as deepfake. The issues for you to decide on Ms. Pete's claim of promotion of an altered sexual depictions are: first, either Ms. Cooper willfully or maliciously promoted an altered sexual depiction of an identifiable person, namely Ms. Pete. Second, Ms. Cooper promoted an altered sexual depiction without the consent of Ms. Pete. Third, at the time of promotion, Ms. Cooper knew or reasonably should have known that the visual depiction was an altered sexual depiction. I will now define some of the terms you must consider in deciding this claim. Altered sexual depiction means any visual depiction that, as a result of any type of digital, electronic, mechanical, or other modification, alteration, or adaptation, depicts a realistic version of an identifiable person, one with the nude body parts of another person as the nude body parts of the identifiable person. 2, with computer generated new body parts as the new body parts of the identifiable person. Or 3, engaging in sexual conduct in which the identifiable person did not engage. An identifiable person means the person in the image is recognizable as a real individual, for instance, by their face, likeness, or other distinctive features, such as a unique birthmark. Willfully means that Miss Cooper acted knowingly, intentionally, and purposefully. Maliciously means Miss Cooper acted with wrongful intent. For example, intentionally doing a harmful act without any lawful jurisdiction justification. Justification or excuse. To promote means to distribute or disseminate material, including issuing, selling, giving, lending, delivering, transmitting, publishing, posting, circulating, exhibiting, or sharing it, or agreeing to do any of these actions. Without consent means Miss Pete did not agree to or authorize the altered depiction being shared in any manner. The presence of a disclaimer within an altered sexual depiction which notifies a viewer that the person or persons depicted did not consent to or participate in the creation or promotion of the material, or that the person or persons depicted did not actually perform the actions portrayed. It is not a defense and not relieve or relieve a person of liability under the law. If you find that all of the above elements are proven by the preponderance of the evidence, then you should find for the plaintiff on this claim. However, if the plaintiff fails to prove any one of the elements, you must return a verdict for the defendant on the claim. Now we're going to instruction 23, defamation and intentional infliction of emotional distress. If your verdict is for Ms. Cooper on defamation and intentional infliction of emotional distress, you will not consider the matter of damages. But if the greater weight of the evidence or preponderance of the evidence supports either of Ms. Pete's claims for defamation or intentional infliction of emotional distress, you should determine and write on the verdict form in dollars the total amount of loss, injury, or damage which the greater weight of the evidence shows will fairly and adequately compensate Ms. Pete for her loss or damage, including any damages that she is reasonably certain to incur or experience in the future. You shall consider the following elements of damage. So as y'all see here, we do have quite a bit of points. So let's go ahead and read over them. So A is special damages. If you find that Miss Pete and against Miss Cooper on Miss Pete's defamation claim, you may award special damages. Special damages are damages which are awarded because statements Ms. Cooper made rose to the level of defamation per se, as I described. B, nominal damages. If you find for Ms. Pete, but find that no damage has been proved for her intentional infliction of emotional distress claim, you may award nominal damages. Nominal damages are damages of an inconsensual amount which are awarded to vindicate a right where a wrong is established but no damage is proved. By nominal, I mean a dollar amount of damages such as $1 that you, in your discretion, determine. Compensatory damages. If you find for Ms. Pete and against Ms. Cooper on Ms. Pete's intentional infliction of emotional distress claim, you may award compensatory damages. Compensatory damages are damages amount awarded for medical expenses for Ms. Pete. These compensatory damages are for the reasonable value or expense of medical care and treatment necessarily or reasonably obtained by Ms. Pete in the past or to be so obtained in the future. Lost earnings, lost working time, lost earning capacity. These compensatory damages are for any earnings, working time lost in the past, and any loss of ability to earn money in the future. Any loss of ability to earn money sustained in the past and any such loss in the future. Injury to reputation. Now this could be something. Injury to reputation or health or shame, humiliation, mental anguish, hurt feelings, the compensatory damages, or for any injury to reputation or health, and any shame, humiliation, mental anguish, and hurt feelings experienced in the past or to be experienced in the future. There is no exact standard for fixing the compensation to be awarded on amount of such elements of damage. Any award should be fair and just in the light of the evidence. Punitive damage. There is an additional claim in this case that you must decide. If you find that Miss Pete and against Miss Cooper on her claims for defamation or intentional infliction of emotional distress, you must decide whether, in addition to compensatory damage, punitive damage are warranted as punishment to Miss Cooper and as to deterrent to others. Ms. Pete claims that punitive damage should be awarded against Ms. Cooper for her conduct in coordinating with Mr. Daystar Peterson and his affiliates to distribute, promote, and disseminate false and disproved statements and theories about Ms. Pete, and to intentionally or recklessly promote and distribute an altered sexual depiction of Ms. Pete. Punitive damages are warranted against Ms. Cooper if you find by clear and convincing evidence that Ms. Cooper was guilty of intentional conduct or gross negligence, which was a substantial cause of loss or damage to Mrs. Pete. Under those circumstances, you may, in your discretion, award punitive damages against Ms. Cooper. If clear and convincing evidence does not show such conduct by Ms. Cooper, punitive damages are not warranted against Ms. Cooper. Intentional misconduct means that Ms. Cooper had actual knowledge of the wrongfulness of the conduct and that there was a high probability that injury or damage to Ms. Pete, and despite that knowledge, she intentionally persuaded that course of conduct resulting in injury or damage. Gross negligence means that Ms. Cooper's conduct was so reckless or wanting in care that it constitutes a conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct. And then we're going to get into instruction 24. We're almost at the bottom. We're on page 37 to 39, so we're almost there. So this is statutory damages, promotion of an altered sexual depiction. If your verdict is for Ms. Cooper on promotion of an altered sexual depiction, you will not consider the matter of damages. But if the greater weight of the evidence or preponderance of the evidence support Ms. Pete's claim for a promotion of an altered sexual depiction, then the law allows Ms. Pete to recover monetary damages in an amount of $10,000 or actual damage incurred, whichever is greater, for each instance that occurred, and reasonably attorney fees and costs. And then instruction number 25, which is 3.8.1, duty to deliberate when only the plaintiff claimed damages. Of course, the fact that I have given you instructions considering the issue of Ms. Pete's damages as to any of her claims should not be interpreted in any way as an indication that I believe that Ms. Pete should or should not prevail in this case. Your verdict must be unanimous. In other words, you must all agree. Your deliberations are secret, and you'll never have to explain your verdict to anyone. Each of you must decide the case for yourself, but only after fully considering the evidence with the other jurors. So you must discuss the case with one another and try to reach an agreement. While you're discussing the case, don't hesitate to re-examine your own opinion and change your mind if you become convinced that you were wrong. But it says, but don't give up on your honest beliefs just because others think differently or because you simply want to get the case over with. Remember that in a very real way, your judges of the facts. Your only interest is to seek the truth from the evidence in this case. And then we're going to get into instruction number 26, which is 3.9, election of foreperson, explanation of the verdict form. When you get to the jury room, choose one of your members to act as foreperson. The foreperson will direct your deliberations and speak for you in court. A verdict form has been prepared for your convenience. Explain verdict. Take the verdict form with you to the jury room. When you've all agreed on the verdict, your foreperson must fill in the form, sign it, and date it. Then you'll return it to the courtroom. If you wish to communicate with me at any time, please write down your message or question and give it to the court security officer. The court security officer will bring it to me and I'll respond promptly as possible, either in writing or by talking to you in the courtroom. Please understand that I may have to talk to the lawyers and the parties before I respond to your question or message. So you should be patient as you wait my response. But I caution you not to tell me how many jurors have voted one way or the other at that time. That type of information should remain in the jury room and not be shared with anyone, including me, in your note of question. And that is the bottom of the page. So I will have this entire court document in the description box below. And what do you think? So we have gotten three pieces, right? We have got the verdict form, we have gotten the jury instructions, and we also have received, for example, exhibits. So there is a lot of moving pieces with this case. And we have pre-trial stipulations as well. So what do you guys think? Like, share, and subscribe. And as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, I'll see y'all next time. Peace out.